Hello, I'm Casey Welch, and we're continuing the discussion of John Fuller in my book, American Criminal Courts, Legal Process and Social Context. In this chapter and video, we're going to discuss case assessment. Case assessment is actually used by both the prosecuting attorney as well as a defense attorney, but for this video, we're going to focus only on prosecutorial case assessment. When we refer to case assessment, what we mean is the evaluation of the strength and legality of the evidence and the decision of whether to dismiss a case or to charge the defendant with a crime. Case assessment involves legal reasoning, categorization of cases as conforming or exceptional. That means whether they're typical or unusual. Prioritization of cases. In other words, is a rape more important than an armed robbery in some jurisdictions? Organizational resources and customs, and consideration of external factors. Evidence during case assessment will be reviewed repeatedly, substantive laws read, witnesses interviewed, the case will be vetted with other attorneys, experts consulted, substantive laws reread, judges consulted, and hearings held. All of this is happening as the case is moving from one pretrial stage to the next, and at each stage, the prosecutor must decide what to do at the next stage. This is arguably the most important set of variables in the criminal court process because it impacts the caseload of the prosecutor's office, but also the lives of millions of people. But it can't be pinned down to a single decision or a single stage. It's not a lawyer sitting in a room reviewing a case file once and making a definitive decision at that time of whether or not to charge a case and go to trial. It's a process. And this process of case assessment involves both the exertion of state power as well as the protection of due process rights, and it hinges on legal reasoning. Legal reasoning involves, first and foremost, the review of evidence. And the two prominent questions a prosecutor asks while going through this case assessment process is the evidence sufficient to win at trial, and is the evidence admissible? So they'll evaluate all the evidence based on that. While doing this assessment, prosecutors will often develop a case theory. This is where they specify their legal strategy. They actually write it down in a notebook. They specify their legal strategy and also bring to bear a storytelling aspect of the case that taps into the emotions. This legal reasoning and case theory will be tremendously helpful in preparing for motions, discovery, and the trial itself. Now, during the development of the case theory, prosecutors will often either include forensics evidence or at least take into account what forensics evidence will be presented at trial. And this presents a significant problem in the United States. More than most other countries, United States courts rely on forensics evidence. However, the National Science Academy recently released a report that concluded that no forensics evidence, with the exception of some DNA testing, has ever been tested and verified by independent scientific research. In other words, it's basically folk science. It's tradition, it's intuition, it's guesswork. This includes arson analysis, bite mark analysis, ballistics, fingerprints, shoe prints, tire prints, all of that. But it also includes psychiatry, the use of psychiatry in cases. And this is where I want to highlight one example. There's a documentary, Thin Blue Line, directed by Errol Morris. And he analyzes the conviction of Randall Adams, who was sentenced to death for killing a police officer. Now, that death sentence was the result of Dr. James Grigson's recommendation. And Grigson's conclusion was based on his analysis of drawings and sketches by Randall Adams, not by actual analysis or interviews with him. Dr. Grigson also had the nickname Dr. Death because he had made the same type of testimony in hundreds of other capital cases, often without ever having even met the defendant. In the Adams case, he actually testified that the only way to stop Adams from killing again was to execute him. And he was successful in persuading the court to sentence Adams to death. The film, however, compelled the court to review the case, which revealed that the prosecution used witnesses that gave perjured testimony. The prosecution did not give evidence to the defense that is required by law, and the judge gave contradictory jury instructions. After 12 years in prison and on death row, Randall Adams was released. This is just one of many examples of how the use of forensic evidence, in this case psychiatry, is problematic in case assessments and trials, and in fact possibly dangerous and unjust. Thank you for joining us in the discussion of case assessment and case mobilization. In our next chapter, we're going to look at how the pre-trial stages lead up to the trial. Thank you.